abusuya micha na misanso mo akwa bason koso enfa mo channel so hada so ye be media gh abusuya for eyade a eye ECOWAS court yes ECOWAS court atumi abo eye mami eye former chief justice eye Gertrude Isaba Torkonoo ye magati na dia ECOWAS abusuya abo eye ni application no omo abo ato agu na abusuya we na ma eye lecturer bakon owo eye University of Ghana abusuya wa ba bonten no ba bedi nkomo ochene semu a eyade a eye ECOWAS court yes omo abo eye ye mami eye Gertrude Isaba Torkonoo na application omo abo ato agu mom de na mum enoma bi wo ho a se His Excellency John Dramani Mahama abusuya no so ehwe na odi ema eye ye mami na chese asem emfa na asem enko na abusuya ochira ne benefit a se ohia no His Excellency John Dramani Mahama enhwe na onfa ema eye ye mami abusuya we de mami kasa wampese ye kone kote nsem no mu ankasa enchire mu emfa mfiri eye joy news na se wie na so wadwo nchire bi abusuafo ya bomodin na ya kire ya adwo hada so ebe media gh se ena de kon ye twa channel so a abusuya ye be se waso beje mra video si bi abodi a waso subscribe like na wa bo aso ahia ma wo for person bi atie no anya bi atie ye ntie nkoma abusuya e so emra sesia ha
ECOWAS Community Court has this morning dismissed an application filed seeking interim measures to suspend her removal and restore her to office with full entitlements. According to the court, the application failed to meet the criteria required for the grant of interim reliefs. It held that Justice Araba Torkonoo had not demonstrated any, quote, imminent or irreparable harm, unquote, that would justify the urgency of the request, especially as the application was filed almost 3 months after the alleged violation. The court further noted that the applicant's own conduct undermined her claim of urgency. As a result, it declined an assessment bid to assess the remaining requirements for provisional measures, which it described as cumulative. With a request for interim promotion measures as deemed unsubstantiated, the court dismissed the application in entirety. Well, dismissing the preliminary objection, the court held that Justice Araba Torkonoo had a prima facie case of a violation of her fundamental human rights, and that ruling that the High Court had jurisdiction to hear the case. So there are two different cases. Now, the Attorney General has been given 30 days to file his response to the former Chief Justice. And that is the update we have for you this afternoon. We've been speaking to lawyer for the former Chief Justice, Gertrude Araba Torkonoo, Aikwe. He spoke earlier on JN Today, and he has been providing details about the court's decision. We'll be back in the studio to discuss that, but listen to this.
I don't see anything newsworthy about what we are talking about. We're all in this country. When the government was sued in the ECOWAS court, we knew exactly what the lady was asking. And yet, we went ahead and announced a new Chief Justice. The person went through vetting. The minority tried to draw attention to the pendency of these issues. Parliament will not have none of that. The minority had to walk out. Eventually, the person nominated was vetted, and the person was then sworn into office. What do you think is the effect of all this on the case? They have to say, place a fear complete, on them. That, look, we have done all these things already. So what's the point of you going to hear this application? So to me, this thing is not newsworthy. There's nothing to talk about because we all know that as we speak today, there is a new Chief Justice who has even been sworn in. So what are we looking for? You
but think that the application, did you?
Reverse it and go back or what? There's nothing. That's why they are saying, let us go into the merits of the case. Since the application was filed, they have refused to respond to the case itself. And the court is saying, go and file your response within 30 days and come and let us go into this matter. As for this preliminary offense, it's of no use, it's of no value, because you have fixed them with sheer accompli already. You've done all that you want to do. So who hear this matter? Let us go into the full matter itself.
Okay.
That is my take on this matter.
So, per our simple understanding, this does not affect the ledger of the substantive matter at all, in any way?
At all, because when this case was filed, the first thing they told everybody was that the ECOWAS court has no jurisdiction. Some of us kept telling them that it is not true. The ECOWAS court operates whether or not a case is pending in your country. ECOWAS court will still hear, so long as it has to do with the violation of human rights. But they were too full of themselves, kept saying that the court will dismiss it because there are pending cases in the Supreme Court, High Court, and so, which have not been dealt with. Now that ruling has gone against them, that they should file their process and let's hear the matter. Rather, they are talking about this, excuse my language, useless ruling. What is the point? What would that achieve when they have gone ahead and done everything that they wanted to do on this end regarding the new appointment?
Is this,
what is the value?
Is this normal?
To me, it is of no news. But what is newsworthy is that their preliminary objection has been dismissed and they have been given 30 days to file their processes.
Okay, and so you're proceeding with or without? You're proceeding to the most substantive matter.
That is it.
Well, let's flesh this out here on the pause. Joining me now is a lecturer at the University of Ghana School of Law, Professor Kojo Piejetia. We appreciate your time here on the pause. We've just been hearing the official response of ECOWAS Court. Earlier, we've heard different legal arguments that ECOWAS Court lacked jurisdiction to even hear the substantive case, which has to do with the abuse of her fundamental rights. Now we've been hearing from the court just tell the Attorney General that they need to file a defense. And so that argument about the court getting or lacking jurisdiction, we got it wrong, did we not?
Hello?
Yes, Prof. I can hear you loud and clear.
Okay. Can you, there was a break in the...
Okay. I was just wondering, the argument about ECOWAS Court lacking jurisdiction in this case is one that individuals, especially in the legal field, have raised time without number. But today we heard from ECOWAS Court just directing the Attorney General to issue a direct response to the allegations made by the former Chief Justice on the substantive case with regards to the abuse of her rights. So clearly we got it wrong when it comes to the assumption that ECOWAS Court lacked jurisdiction, did we not?
Yes, certainly. The ECOWAS Court doesn't lack jurisdiction with the particular case that was brought before it by the former Chief Justice. The point is that the court is set up to deal with human rights cases. And so where there's a violation of a right of a citizen of ECOWAS, that person is entitled to bring a matter before the ECOWAS Court of Justice, irrespective of where the case has been, or whether it's a case has been initiated at all before a local court. And this is an important exception that the ECOWAS Court of Justice has, because normally one would have been expected to exhaust local remedies, that your matter should have traveled all the way to the Supreme Court or the highest court of the land, and you lost the case and you still feel aggrieved, or you don't feel that your matter has been addressed properly, or you've received the required redress before you can go to an international forum. But there's some exceptions that the ECOWAS Court has, and that is on the basis on that it ruled that the case can go ahead, and therefore Ghana as a state has 30 days to respond to the petition sent by the former Attorney General.
And should the court establish that indeed her human rights were abused throughout the process, what does that mean for the procedure she was subjected to that even led to her removal from office?
Yes, as things stand now, But first of all, let me react to the basis for the rejection of the temporary measures. I think that there was the decision is, I don't fully agree with the basis for the decision, because I think the question that was raised by the former Chief Justice is that there was a problem with how the committee was conducting itself.
Okay.
And so it was at that point that she began to raise issues about the whole process. And so if that was a starting point, then in my opinion, there was no delay on her part, and therefore the issue of the emergency issue involved, I don't think it arises.
But then if you just look at the court and the concerns they have raised, really, in filing her case, pushing for the injunction, she made the argument that if they do not intervene, there would be imminent or irreparable harm. Now, they raised concerns that it took her 3 months, really, to file that application. If you raise concerns about the urgency, should you not have acted earlier? That's the court's position.
That's why I'm also saying that it was at the level of when the matter, she raised the issue about how the committee was conducting itself, at least according to the father, that's what I know. And if that is at that point, then it means that she did not question the process before then. And so time will begin to run against her from the time the committee began to sit and she had concerns raised about how the committee was conducting the whole process.
We already have a substantive Chief Justice that has been sworn in already. Should the ECOWAS court determine that indeed the former Chief Justice, Gertrude Torkonoo, was subjected to any form of human rights abuse, what does that mean for the process that led to her removal?
At this stage, what I feel is that the court will not rule regarding her ability to come back to the position of a Chief Justice, or let alone a member of the Supreme Court. But it is likely they may find a case of violation of her rights. She raises a number of human rights violations, such as the right to work and fair trial and so on. It is possible she might win one of those grounds, and the government may be asked to compensate her for the rights that were violated in that respect. But it wouldn't be about coming back to or removing the currently installed Chief Justice and bringing her back to that position. Having said that, I also want to chip in and say that the delay on the part of the court in giving the preliminary ruling is also something that is of concern, because this is a temporary measure that they applied for. And normally, such applications are attended to with dispatch, so that it will avoid the situation where, at this case, it becomes moot, as Mr. Ayiko Otu rightly said. So such matters is like making an application for injunction before a court. It has to be heard as quickly as possible to so that any rights that are likely to be violated can be addressed before the substantive case is gone into.
But should the court indeed rule that her human rights were violated in any way or form, doesn't that question now the competence of the committee set up, the Justice Poman Committee, to look into the even case itself that led to her removal? What legal revenues then will be available for her, or avenues that would be available for her moving forward, should the court rule in her favor?
The kind of justice or redress you get out of that will be some form of reparation, and it may come in the form of compensation, some monetary compensation that should be paid to her for the damage to her reputation.
But isn't that enough bait to go and challenge the current Chief Justice and demand her reinstatement?
Like I said earlier, it may not result in the reinstatement of the Chief Justice. At this stage, we've gone past that stage. So it's going to be a situation where human rights, some compensation will be enough to address.
So it's fair complete based on what you're telling me. So then it raises the question, really, if she's fighting a lost battle, why then embark on this journey in the first place?
Well, I think when she started, we had not reached this stage. And having reached the stage, I think there are a number of demands that she brought before the courts. So if one doesn't succeed, I think another can succeed. And that is the human rights reparation that she's asking for. So it wouldn't be nothing at all. There might be some compensation for the harm that has been caused to her reputation.
We have an ambitious new Chief Justice who's hoping to restore confidence in the judiciary. He has a daunting task ahead of him, looking at the circumstances that led to his appointment, as well as the removal of the former Chief Justice. As we just look at the judiciary now, zooming into the work of the judiciary, can we indeed say the judiciary is independent, looking at all the incidences that have happened, and how really can this new Chief Justice restore confidence in the judiciary?
Well, of course, we all know that the image of the judiciary has been battered seriously as a result of the circumstances surrounding the removal of the Chief Justice. But I think we cannot question the integrity of the current Chief Justice. He has proven himself over the years that he has been on the bench to be a capable, competent, and independent-minded person. So the hope is that he'll be able to restore confidence in the judiciary, and that will help to ensure that we'll be able to rely on the judiciary. The image of the judiciary will be improved, and people will have trust and confidence in the judiciary. But that alone may not be enough. We already have questioned the procedures through which the Chief Justice is appointed and the way that the Chief Justice is removed. So we are looking forward to the recommendations of the committee set up by the President to review some provisions of the Constitution and make recommendations for changes. So certainly that should address, for example, the issues that we have identified as gaps and loopholes, which the present administration exploited to cause the removal of Justice Torkonoo from office.
Thank you so much, Prof, for your time here on The Pulse. Well,
Student Loan Trust, together with the yet to be established Ghana Scholarship Authority, will collaborate to see to the disbursement of that. I'm praying that in the next couple of weeks, the President will assent to the bill if Parliament finishes its part of the work and sends the bill for presidential assent in accord with Article 106 of the Constitution. So there will still be free tertiary vocational education. And that's why I said that the financing allocation for the Ministry of Education and its agencies may not be sufficient, but at least adequate for now and adequate within the constraints of the budget. Don't forget, ladies and gentlemen of the media, a few of you are here. I still recall before 2025, one of the most nagging questions the media asked the NDC and President Mahama was, show us one social intervention policy of your government. We have sufficiently and adequately provided and answered the Ghanaian public. I have identified three. Those of you who are more intellectual than me can add the additional ones. Mahama Cares is a social intervention policy. No fee stress is a social intervention policy. Free education for persons with disability is a social intervention policy. And therefore our critics, you are now naysayers because we have answered you and answered you adequately. That under President Mahama's research agenda, we have responded adequately, and he would leave that as an enduring legacy of the Mahama presidency. And no academic fees policy for all first-year students, you would note that some 537.4 million has been allocated for that purpose, representing 7.6% from what was allocated in 2025. And many of the students are grateful for that intervention, and that takes a burden off parents and the students. And for President Mahama and the Ministry of Education, no child should be left behind because the person is financially disadvantaged. And therefore, we have also expanded the remit of the student loan trust into the +1 they have. Even students of Ghana School of Law who hitherto did not benefit from it, we've expanded it for them to benefit. So in total, 4.2 billion has been dedicated to sustaining and improving the free senior high school and free TVET program. This investment will ensure that every Ghanaian child, regardless of background, has access to secondary education. We will do everything possible. Last year, it was 3.5